Chairman, members of the tribunal, good morning again. My co-counsel will deal with the merits, and I will address the procedural issue of this case, which are the admissibility of Mr. Short's witness statement and the law applicable to the form requirements of the contract. I will speak for 13 minutes, keeping 1 minute for rebuttal, and my co-counsel will speak for 15 minutes, keeping 1 minute for rebuttal. Regarding Mr. Short's witness statement, Mr. Short is a key witness for the respondent. Mr. Short won't attend the hearing due to his new employer's company policy. And for this, the claimant submits that the tribunal should disregard his witness statement. However, all the procedural rules applicable before this tribunal lead to the admission of the statement of Mr. Short into evidence. This will raise 3 points, which I will list and then develop. Firstly, the CIAC rules provide the parties with the right to present witness statements in writing. Secondly, Mr. Short has a valid reason not to attend the hearing under the IBA rules.
Counsel, the IBA rules, can you just clarify for me how those are implied into these proceedings?
There is no explicit agreement of the parties on the application of the IBA rules, and because the CIAC rules provide for witness statements, the respondent believes that the IBA rules are irrelevant here. But the respondent is aware that it is international business practice in international arbitrations to take the IBA rules as a guide. So if this tribunal decided in its discretionary power to take the IBA rules as a guide, then the respondent argues that Mr. Short has a valid reason under these rules for not attending the hearing. And so this leads me to the third reason why the statement of Mr. Short should be admitted into evidence. Under the model law and the New York Convention, which are also applicable to this arbitration, a party must be able to present its own case in order for the award to be enforceable. So moving to the first reason why Mr. Short's witness statement should be admitted into evidence. Article 27.2 of the CIAC rules provides that witnesses may produce statements in writing. This means that first, the parties are entitled to produce witness statements in writing, and second, that cross-examination is not a mandatory condition in order for these statements to be admitted into evidence.
But Counsel, Article 17.3 of the CIAC rules discusses the arbitral tribunal shall hold hearings for the presentation of evidence. Is this not cross-examination?
Article 17.3 of the CIAC rules also, like Article 27.2, provides an entitlement for the parties to hold hearings if this is in the arbitration agreement. But this does not mean that cross-examination is a mandatory condition in order to admit a statement into evidence. Both are rights for the parties.
Counsel, I see we have the power according to the rules, but what about, do we really need this cross-examination? Don't we know what happened? Don't we already know what happened between Mr. Short and Mr. Long? Is that the substance of their agreement known already?
Well, this is correct, Mr. Arbitrator. Both statements of Mr. Short and Mr. Long agree on the main facts of the telephone conversation of the 9th of February of 2011 regarding the change of the delivery date in a contract. The only difference between the two statements is the interpretation that each person had of this conversation. And Mr. Short's witness statement is the only evidence of the respondents. And it's the evidence of the respondent on what happened during that conversation. So in order to decide fairly, the tribunal should consider both statements and both interpretations of this conversation.
Okay, Counsel, if the tribunal does agree to admit this statement, I mean, how should we compensate for the fact that Mr. Short is not here to be cross-examined?
Well, Firstly, there is a huge time gap between the statement, which was written on the 18th of August of 2011, and this arbitration, which takes place in 2013. And in the procedural order number 2, page 55, paragraph 27, both parties reckon that they don't remember the exact words of the entire conversation. So no new elements can be raised from a cross-examination. So the purpose of the cross-examination would be to test the credibility of Mr. Short. And since Mr. Short agrees with Mr. Long on all the relevant aspects, factual aspects of this conversation, then his statement is credible. They're both saying the same thing. It's only the interpretation which changes. So the respondent never asked to cross-examine Mr. Long because of these 2 reasons. And the respondent is willing to waive its right to cross-examine Mr. Long because the respondent does not believe that cross-examination is necessary here. So, as to the second reason why this tribunal should admit Mr. Short's witness statement, under the IBA rules, which again were not agreed on by both the parties and are irrelevant in the position of the respondent, Article 4.7 of these rules provides that if a witness whose appearance has been requested fails without a valid reason to appear before the tribunal, then the tribunal shall disregard his witness statement, unless, in exceptional circumstances, the tribunal decides otherwise. So if the witness can provide valid reasons or exceptional circumstances, then his statement should be admitted into evidence even if he does not attend the hearing.
Okay, Counsel, what are these exceptional circumstances in this case?
Well, the exceptional circumstance, Mr. Chairman, is that the respondent only has this piece of evidence to present. And it's, if the respondent cannot present this piece of evidence, then it cannot present its case. It's unable to present its case.
But what are the exceptional circumstances that are preventing Mr. Short from attending?
Well, first, the respondent cannot compel Mr. Short to attend the hearing since the respondent has no power whatsoever on Mr. Short because he changed employer. His new employer expressly forbid him to come to the hearing. And second, this tribunal cannot compel Mr. Short to come to the hearing because neither the laws of Danubia nor Equatoriana provide for court assistance in the mandatory appearance of witnesses in oral hearings.
Okay, has the question been asked of Mr. Short's employer or only Mr. Short himself?
The respondent called Mr. Short to inform him that Mr. Fastrack, the lawyer of the claimant, wanted to cross-examine him. This is on page 48, procedural order number 1. And Mr. Short firmly answered to this phone call that it's his new employer's company policy to avoid that employees avoid involvement in third-party actions, so that his employer urged him specifically not to come to this hearing. And the respondent would not advise his former employee to disobey to the orders of his new employer.
Okay, Counsel, what would normally be a definition of exceptional circumstances?
There is no legal definition of exceptional circumstances, but only doctrinal ones. The doctrine of Anne-Veronique Schlepfer defines exceptional circumstances as, for example, death or sickness. But this does not mean that the fact that the respondent only has this piece of evidence is not an exceptional circumstance. What is an exceptional circumstance? It's something that doesn't happen often and it is rare. It is rare that a party only has one piece of evidence to support its submissions. So this is an exceptional circumstance in accordance with respondent's submission. Now, under the terms of Article 4.7, Mr. Short also has a valid reason for not attending the hearing, and this valid reason being the refusal of his new employer, as already discussed. So under the terms of this Article 4.7 of the IBA rules, Mr. Short has a valid reason not to come, and in any case, these are exceptional circumstances, so his witness statement should be admitted into evidence. this tribunal has a wide discretionary power concerning the admissibility and the weight of evidence. And this leads me to the third reason why the statement of Mr. Short should be admitted into evidence by this tribunal. Article 19.2 of the model law provides that this tribunal can give the weight it deems appropriate to any piece of evidence. This means that this tribunal can weight Mr. Short's evidence in light of Mr. Short's non-appearance, thus respecting the equal treatment of the parties' principle in the perspective of the claimant.
Excuse me, counsel. Do you really think that the non-appearance will improve your position in comparison to the appearance of Mr. Short? Because you say we have discretion to weigh the evidence before us, and if we merely admit the written witness statement, do you think that improves your position and submits your argument in a better way than the appearance of Mr. Short?
I understand your concern, Madam Arbitrator, but here it's not a question of what would be the best position for respondent. It's a question of procedural fairness. And if the tribunal disregards the statement of Mr. Short, this deprives the respondent of the right to present its own case. And this would be grounds to set aside the award and refuse its recognition and enforcement under Article 34.2 of the Model Law and 5.1.b of the New York Convention. So, for all these reasons, the statement of Mr. Short should be admitted into evidence according to the CIAC rules, the IB rules, the Model Law, and the New York Convention. Now, if the tribunal has no further questions, as my time is running up, I'd like to address the applicable law issue. Thank you. The respondent submits that this contract can be modified orally. First, because the parties excluded Mediterranean's Article 96 reservation from the applicable law to the contract in the clause 20 of the contract. If I may refer the tribunal to this clause, clause 20 of the contract, page 13 of the record. This is the applicable law clause, negotiated on the basis of a contract model used by the claimant. And this clause states, and I quote, that the CISG is applicable without regard to any national reservation. So it was clear the party's intent to exclude national reservations from the applicable law of this contract. And party intention is a general principle of the CISG and a general principle in international arbitration.
But Counsel, wasn't that really written into the CIAC rules? That was a specific issue to do with trade between Europe and China.
Yes, this is a model clause taken from Article 35 of the CIAC rules. But this Article 35 was expressly written, and this, according to Professor Christine Haig and Florence Broch, Article 35's wording was deliberately chosen to exclude China's Article 96 reservation from the applicable law of the contract.
Counsel, this is a nice statement, but only because Professor Haig says that it was explicitly put into the CIAC rules in order to override the 96 reservation of China. Is it valid? I mean, we have the CISG is an international covenant. The CIAC rules are merely arbitration rules of an arbitration institution. What principle overrides? I mean, I do think that the international law overrides the CIAC rules here.
Well, I understand your concern, and this leads me to my second submission, if I may have extra time, because my time is running up now.
How much time do you need?
You're
2
already
minutes.
2 minutes over,
Yeah,
so
2
I think
minutes. 2
not too
minutes.
much.
No,
Otherwise,
okay.
it's on
Well,
five.
we'll make sure that you get an equal amount of time. So, okay, you have 2 minutes.
Well, Article 96 declaration made by the State of Mediterranean According to a majority body of opinion, this Article 96 reservation and Article 12 of the CISG, which forbids any derogation from this reservation, both articles do not address the question of which is the national law applicable to the form requirements of the contract. If you look at the wording of these articles, nowhere does it say that the law of Mediterranean, who made an Article 96 reservation, the law of the country, which has its place of business in a declaring state, is the law applicable to the form requirements of the contract. These two articles only allow a contracting state to derogate from the freedom of form principle of the CISG. And according to this majority jurisprudence, Article 96 itself does not bind the parties which trade with companies who have their place of business in a declaring state. In this situation, Article 7.2 of the CISG calls for application of the international conflict of law rules of the forum to determine which is the national law applicable to the form requirements of the contract. If it's the law of Mediterranean, the contract can only be modified in writing. And if it's the law of Equatoriana, the contract can be modified orally. So if I may refer the tribunal to page 56, paragraph 33, the international conflict of law rules of the forum, which is Danubia.
What page again? Sorry?
56.
Sorry, 56.
Oh,
Thank you,
56,
Mr.
yeah.
Rodriguez.
Page 56.
Yes, paragraph 33. This clarification states that the law applicable to the contract in the states of Danubia, Equatoriana, Mediterranean, and Oceania is the law with which the contract has the closest connection. And in determining such closest connection, different factors play a role, including the place of conclusion of the contract, which in this case is Equatoriana, and the place of where the party making the characteristic performance has its place of business, which is also Equatoriana. So, following the closest connection method, the law of Equatoriana is applicable to the form requirements of the contract, and the contract can be modified orally, because in Equatoriana, contracts can be modified orally. Now, this was my last submission, and accordingly, the respondent respectfully asks the tribunal to find that Mr. Short's witness statement should be admitted into evidence, and that this contract can be modified orally. Thank you.